This Honorable Court of Appeals is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. I appreciate both of you agreeing to hear this matter via Zoom oral argument. Also appreciate the fact that you've agreed to, on such short notice, have this matter heard, which brings up an issue that I want to speak with you about. I know there's been some email exchanges with Mr. Hibner about whether this matter should be live streamed or whether it should be posted to the internet after this is heard. First of all, because you've had very short notice and all you've been able to do is express your opinions about whether this should be live streamed, the court has made an executive decision that we will not be live streaming this matter. However, we will be recording this matter, and unless the court comes to a different decision, it very well could be posted to the internet within 10, 12 days, something like that. But in the interim, since you have expressed your opinion about whether it should be posted, I'm going to give each of you an opportunity to file whatever you'd like to file with the court to consider about whether it should be posted to the internet. I know both of you have expressed different opinions in your correspondence with Mr. Hibner, but you didn't have much time to develop that, and you certainly didn't have time to file whatever you wanted to file. So I'm going to give you that opportunity. We certainly won't post anything for at least the next 10 or 12 days. So if you could file whatever you're going to file, say by the end of the week, that would certainly be helpful to us. As I say, we're not live streaming. However,
I'm sorry.
Oh,
go ahead.
I'm sorry.
No, go ahead, Mr. Judge Stafford. I'm sorry. I didn't mean to interrupt you.
Oh, okay. We will begin oral argument shortly. And when we do begin oral argument, the same rules and procedures will be utilized here as if we were standing in the courtroom. What that essentially means is each side gets 15 minutes to make its oral argument. If you're the appellant, you've reserved rebuttal time with Mr. Hibner, you'll receive that rebuttal time as well. I know we've got people watching here, and as long as they remain muted, that's fine as well. Before we start, though, I want to introduce the panel for today. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Hibner, anything we need to take up before we call the case?
No, Your Honor.
All right. Did you call the case a minute ago before I started doing all this talking?
I have not called the case yet, Your Honor.
Okay. All right. Go right ahead, please.
Dillon Brooks versus Heathery Avery Andrews.
Okay. We will now hear from the appellant.
May it please the court. I am Joseph Smith, along with my co-counsel, Gil Bowie. We represent the appellant, Heather Avery Andrews. For purposes of today's argument, I will refer to the appellant as mother and the appellee as father. At issue before the court is whether father had standing to file his December 2020 complaint in Shelby County Chancery Court. It's our position that father did not have standing to do so for these two reasons. One, father did not have a right to sue for parentage of a child born out of wedlock in Chancery Court because venue for such actions is in Shelby County Juvenile Court pursuant to statute. Secondly, father did not have the right to sue for immediate emergency custody of a minor child born out of wedlock because parentage had not been established. The following are critical facts.
Let me ask you a question, Mr. Smith. Is parentage an issue here?
Parentage, no. Parentage is not an issue. We have a pending parentage action in California. What is at issue is custody and visitation, which is required for an agreement for parentage to be established.
So everybody agrees that the purported father here is the father?
Yes, Your Honor.
Okay. All right, so go right ahead.
Okay. The following are the critical facts for this court to consider in determining whether father had standing. Prior to the filing of the December 2020 complaint, the parties had dismissed their respective parentage actions in October 2020. Father dismissed his Nevada action and mother dismissed her California action. Since then, no order has been entered that established parentage. No VAP had been executed, VAP standing for Voluntary Acknowledgement of Paternity. And no agreement consistent with Tennessee Code as to parentage has been made. And with the complaint that was filed in December by father, what was sought was essentially three things: to establish custody, temporary emergency custody pursuant to UCCJEA. Secondly, to establish child support pursuant to USA. And thirdly, a restraining order be issued against the mother. With respect to our first argument, the complaint that was filed by the father in December 2020 is one for parentage. That is addressed pursuant to TCA 36-311. That statute controls with respect to an order for parentage. Now, venue for parentage actions is localized by statute. That is TCA 36-307A. So based on our interpretation of the statute, parentage actions involving a child born out of wedlock has to be filed in Shelby County Juvenile Court, not Chancery Court. This interpretation is consistent with the Attorney General's opinion, 10-91, and is not being challenged by the father. Now, father is now asking that this case be transferred to juvenile court if the court finds that Chancery Court did not have subject matter jurisdiction. And it's clear with case law that once this court finds that a court doesn't have jurisdiction, subject matter jurisdiction, dismissal is required. Now, interestingly, the father says on page 36 of his response that he did not have the option to file his complaint in juvenile court in December 2020. We take issue with that. For one, the Supreme Court had issued an order that provided exceptions to the prohibition with in-person hearings. And father's complaint falls exactly within that exception. So as long as the juvenile court Shelby County was following the order issued by the Tennessee Supreme Court, it's just not true that father did not have the option to file in juvenile court. With respect to our second argument, we rely on the analysis that this court had provided in Baxter v. Rowan. Here are the following takeaways. The code provides multiple ways for a unwed father to establish parentage besides 36-311. And an execution of a VAP is one way, among others, to establish parentage. Here, the only route for the father in this matter to establish parentage is through 36-311. So it follows that father lacks standing to seek immediate temporary custody of the minor child. And just to be clear, 36-311 requires that a paternity test be done, and that did not occur. We're not saying that father didn't have standing to sue at all for custody. He did. But mind you, what was requested at the time he filed his complaint was only for temporary emergency custody. At that time, unless father could show that he had a legal right to custody, which he did not, the court had to order paternity testing, and that did not occur. Now, father argues that—
How would he have the right to sue for custody if parentage hadn't been determined and he hadn't signed a VAP? On what basis would he be entitled to sue for custody?
He wouldn't have a basis to sue for immediate custody, but he would have basis to sue for custody because at that time, the court can say, well, let's issue an order for him to undergo testing. Once the results come back that he is the father, then we can establish custody and visitation.
So in other words, prior to that, the court would have to determine parentage.
Correct.
Okay, all right, go ahead.
Correct. In this case, that did not occur. Now, father argues that he has standing due to a DNA test and the fact that mother is asserting that father is the father of the child in California, a pending jurisdiction. Well, here's the problem with that. DNA admissibility is contingent upon complying with testing requirements pursuant to TCA 24-7-112. And there's no legal authority presented by father to support that a DNA test is equivalent to granting one custody, paternity or parentage. Same with the pending action. Although mother is not disputing parentage, there is a mechanism for the parties to agree to parentage. And one of those requirements is that the parties have to agree to custody and they agree to visitation. That's not this case, not to mention that we are currently challenging Tennessee's jurisdiction over this matter. So in conclusion, Your Honor, it's our position that father did not have standing to file his complaint in December 2020. Not only did not have standing to file in Shelby County Chancery Court, but based on what was requested in his December 2020 complaint, he does not have standing to sue in a juvenile court based on what he was requesting. Now, there is a remedy for the father. His complaint alleges emergency allegations. And one route for him to go would be to file in juvenile court an action for dependency and neglect. And he will have standing under the statute. Also, he would be able to obtain an order for emergency custody based on probable cause that the child is dependent and neglected.
In this case, was an evidentiary hearing ever held?
The hearing was ex parte. So I believe evidence was taken, but there was no notice to the mother and no opportunity for cross-examination.
Well, I mean, have you seen a transcript or was evidence presented other than?
Yes, I believe the record includes a transcript from those proceedings.
Okay.
Mr. Smith?
Yes, Your Honor.
I believe you stated that your client has a case pending in California. Is that correct?
Yes, Your Honor. Yes.
When was that filed?
That was filed in January 2021, January 20th, I believe.
Right. And that is an action to establish parentage. Is that correct?
Yes. Currently, they are having a hearing that's set. They had multiple hearings. Ruling has not been made, but I believe they resume in January this upcoming year.
All right. Thank you.
All right. No other questions. We will hear from the appellee.
Thank you, Your Honor. In order to answer, Judge Stafford, you had asked.
Introduce yourself first.
I apologize. I'm eager to get forward. I'm Holly Rankin. I'm here on behalf of the appellee, Dillon Brooks. In my office, as you see behind me, is Ms. Lucy Bracken, who is also representing Dillon Brooks. There are no other people in my office or no other people present.
Okay.
Judge Stafford, you asked a question earlier about an evidentiary hearing in Chancery Court. Chancellor Jenkins did have an evidentiary hearing on December 18th. And the next hearing was January, I believe, 29th, and Mr. Smith was present for that hearing. Ms. Andrews did have notice of the December 18th hearing, but she was not present.
Okay.
If I may. So there are three elements that are necessary to prove standing. You need a distinct injury, you need a causal connection between the injury and the conduct, and you need an injury capable of being addressed by the court. Here, mother's behavior caused the injury.
Let me ask you a very elementary question, I assume.
Certainly.
Before we get into this too deep. As I understand it, both parties admit that the father is the father here. But what is the legal significance of that, since you've got a got litigation ongoing in California. And that seems to, even though there is an admission that he is the father, parentage has not been legally established. So I'm trying to understand the whole ramifications of that.
Certainly. If I may, Your Honor, although Mr. Smith today has readily admitted that Mr. Brooks is the father of this child, up until today, he has not so admitted. There is nothing in his brief, as you have read, that indicates he acknowledges Mr. Brooks's paternity of this child. So this is a welcome acknowledgement for Mr. Brooks. What happened in the courtroom, Your Honor, the transcript is short, but it is very insightful. Chancellor Jenkins asked repeatedly for proof. He asked Mr. Smith to give some assurance of the child's welfare and well-being. Ms. Bracken at that time asked for a legal determination of parentage. The DNA test results are attached to the petition, Your Honor. And according to Mr. Smith, there's no denying that Mr. Brooks is in fact the biological father of the child. Under the Tennessee law, that makes him the presumptive father. And just like using the rationale of Judge Golden's opinion in Baxter versus Rowan, although it does not give him custody rights or visitation rights, it certainly gives him standing to sue for those rights. There was a request for the determination of legal parentage at the same time this petition was filed.
I don't think that that's what that case stood for, though, Ms. Rankin. Didn't that case stand for the fact that when the presumptive father signed the VAP is what gave him the rights to come in and sue for visitation or custody? Well,
in that case, Your Honor, I mean, certainly I don't mean to make assumptions, but I read that case. The voluntary acknowledgement of paternity, in your opinion, said is only one way you can prove paternity. The statute says that if you have DNA test results, you are the presumptive father.
But that case stood for the fact, as I recall, that the signing of the VAP was what gave you the right to come in and seek visitation. Now, it was a specifically provided statutory right if you sign that voluntary acknowledgement of paternity.
Well, certainly
not a DNA test, but the actual signing of the VAP.
Certainly. And you are correct that the Baxter versus Rowan case deals with the signing of a voluntary acknowledgement of paternity. However, in that case, your opinion goes on to cite that there are other ways you can determine parentage other than a voluntary acknowledgement of parentage.
The court could decide. The juvenile court here could decide parentage or signing a VAP. I think those were the two options.
Well, and certainly with the DNA test results, as part of the petition, that was what Mr. Brooks was seeking, was a legal determination of parentage.
Isn't that determined in the juvenile court in Shelby County?
Your Honor, in this case, the filing in juvenile court was not an option. I realized that Mr. Smith said, the Supreme Court made certain ramifications for proceeding during the time of COVID, which is true. But in December of 2020, it's not just the pandemic writ large, but the specific juvenile court building was stricken by a wave of coronavirus, and they practically shut down the courthouse. You could get in, but they were not hearing cases. Because people were stricken with COVID, they were sick.
Does the Chancery Court have jurisdiction to grant parentage? I thought, my understanding is the juvenile court has exclusive jurisdiction in Shelby County to grant parentage.
Well, Your Honor, Chancellor Jenkins gave a very thorough order. And one thing that we have not discussed here at all today.
My question though is, do they have, jurisdiction? He can't just assume jurisdiction. Does he have jurisdiction?
Your Honor, the Attorney General opinion cited by Mr. Smith does not deal with the UCCJEA. And the temporary emergency provisions of the UCCJEA haven't been addressed today at all. In this case, Mr. Brooks had no other option but to file in Chancery Court in order to get any sort of relief or any sort of audience with the judge.
Well, are you saying that the UCCJEA provides another method for parentage to be determined other than the avenue of the juvenile court in Shelby County?
Your Honor, I'm saying that in this case, there was no other option. Mr. Brooks had no other choice, no other court to avail himself.
So, Ms. Rankin, are you saying that the juvenile court of Shelby County was closed?
In all intents and purposes, Your Honor, yes. They had limited their dockets to delinquency and emergency DNN petitions only. And it was taking weeks to get pleadings not heard but filed in the months of December and January.
And I understand that's your position. Was that argued to the Chancery Court, or did the Chancery Court take up that issue?
Your Honor, this case, in terms of that question, procedurally, it was never argued before the court. If I may, so Mr. Brooks filed his petition. Mr. Smith appeared in January.
Let me stop you just a second.
Certainly.
And tell me if I am understanding this correctly.
Okay.
We have a decision from the Chancery Court that says father in this case has standing to file his petition in Chancery Court. We don't, well, no one ever asked juvenile court to hear this matter. Is that correct?
That is correct.
Okay. And
the petition, Your Honor, was unable to be filed in juvenile court at that time.
Unable to be filed or unable to be heard?
Both.
There is no electronic filing in juvenile court?
Your Honor, I attempted to file a petition in December in juvenile court, and it took 3 weeks to file it, not to have it heard, to file it. It's because the staff was so limited during that time because of COVID, they weren't getting it done. I feel like there are more questions, Judge Stafford.
There are, but I'm trying to think about them before I ask them. So,
okay. Judge Golden, everyone is wiping their head. Judge McGee, look, do you have a question?
Well, Ms. Rankin, you said you filed another petition in juvenile court in December of 2020, if I heard you correctly, and it took 3 weeks to get it filed, but you did file something.
That was, Your Honor, I filed that actually the first week of December in 2020, and I did not get notification until December 29th that it had been filed, and that is despite regular phone calls multiple phone calls each week to juvenile court. It had nothing to do with this case, but that is just my experience.
Well, let me try this one more time.
Certainly.
What we have is the Chancery Court assumed jurisdiction of this matter.
Yes, sir.
And what was the basis of that assumption?
The basis of Chancellor Jenkins' assumption is that the opinion cited by Mr. Smith, the Attorney General's opinion, that did not address the UCCJEA was not therefore relevant to the UCCJEA, and mother's refusal to provide any assurances as to the health and well-being of this child, despite the court's pleas to do so. Under that, the court, Chancellor Jenkins, asserted temporary emergency jurisdiction under the UCCJEA. Under those facts.
Those were the facts that were presented to Chancery Court.
That is correct.
And what was presented to Chancery Court regarding the inability of juvenile court to handle this petition, if anything?
Your Honor, it is in the amended complaint. It is in paragraph 6 through 8 of the amended complaint filed by father.
Okay, and what is that?
The facts that I've just presented to you today, which is the dockets were limited in juvenile court and they were not able to be heard. And then it was not an option. And Ms. Bracken, upon presenting her petition to Chancellor Jenkins, when she filed it in December, presented that information to Chancellor Jenkins as well.
So either if Chancery Court did not possess initial jurisdiction in this matter, what I'm hearing you say is this: either it assumed jurisdiction because of the UCC JEA, or 2, because it was an emergent situation.
That is correct, Your Honor. And
so it's one of those 2 options. Is that correct?
That is correct. And as a result of that, if this court finds that Shelby County Juvenile Court does have exclusive jurisdiction, we would ask that instead of dismissing this case, that you would transfer this case pursuant to TCA 16-1-116. As you know, this was the only court available to Mr. Brooks at the time of the filing.
Why was, just being devil's advocate here,
Certainly.
why was Chancery Court any more available than Circuit Court?
Your Honor, I'm trying to answer that as respectfully as possible. Juvenile court is a completely different animal than Circuit Court or Chancery Court. I have, honestly, in my 20 years of practice, I have never had a problem accessing a Circuit Court judge or a chancellor if I needed one. That is not the case in juvenile court, respectfully.
Okay.
Are there any other questions? I mean, I have a minute left, but I feel like I don't know what you.
Well, let me use your last minute.
Certainly.
So, if I'm still struggling with this paternity question. Both sides seem to admit who the father is in this case, but before the father can gain any rights, does a legal determination have to be made? Either do you have to consent in front of a judge, or have a VAP executed, or enter a consent order, or what is the significance of now that both sides admit that the father, the purported father, is the father?
Your Honor, under the UCC JEA, and particularly under the emergency provisions of the UCC JEA, you do not have to have a prior custody order in place, and you do not have to be a biological parent. The plain language of the statute makes that clear, Your Honor. And I'm out of time.
Okay. Thank you. We will hear from the appellant in rebuttal.
Thank you, Your Honor. To answer your question, there is no legal significance. Going back to the analysis of Baxter v. Rowan, the court acknowledged that the execution of the VAP was of legal significance because per statute, it gave the father legal rights. Here, we don't have that. Now, like I stated earlier, there is a way for the parties to have that legal determination made by agreement. That is pursuant to 36-2-305, agreement to establish parentage. And it says the court may enter an order of parentage upon the agreement of the mother and father unless the court on its own motion orders genetic testing. So there is a way. However, it goes on to say that any agreement under this part shall comply with the requirements of 36-2-311. Now, 36-2-311 requires a paternity test to be done, and also that a determination of custody, visitation, and parental access. We don't have that. So again, to the fact that the parties agree that Mr. Brooks is the child's father, that is of no legal significance. And opposing counsel has failed to provide any authority to support that a DNA test despite its authenticity issues and it being just black letter law hearsay, does not give a father legal rights. It doesn't establish, there's no authority for that, at least that I've been made aware of. Now, going to the UCCJEA, the UCCJEA in of itself is not some vehicle to establish parentage. The UCCJEA is merely a procedural means to determine whether which court should have jurisdiction over a particular matter. It doesn't address venue, which is specifically addressed by the parentage statute 362307A, and doesn't address standing to sue for visitation and custody rights. But lastly, Your Honor, it was very troubling for me to listen to the explanation of why counsel decided not to file the action in juvenile court. This is news to me. This is news to the court. As you know, that courts speak through their orders. And the Chancellor Jenkins' order does not mention that there's no other court of resort for Mr. Brooks to file. I don't remember seeing that in the record, Your Honor. What was clear is that Chancellor Jenkins assumed jurisdiction based on the reliance that the UCCJEA 366-219, I believe, I might be mistaken by the numbers, but the temporary emergency authority. Now, again, there has to be some type of vehicle for the court to assert that authority. The court could have asserted that authority under dependent and neglect action, because dependent and neglect actions might rely on the UCJEA, as well as a parentage action. It was clear that the court just did not have authority in this matter, and we asked that this matter be dismissed and remanded to determine fees.
Let me ask you a question. Is there any portion of the UCCJEA that deals with standing that you're aware of in these type situations? Or is standing a state by state determinative question?
It is a state by state determinative question. If one would just do like a copy and paste of the UCJEA and do Control F standing, you'll find it in one section, that is in the comment section. And our reply brief addresses this issue. And essentially, the UCJEA is a mechanism for states to determine who has a person jurisdiction over custody, and then leave that issue of standing up to the states to decide. Now here, parentage actions, the parentage statute addresses standing. It's just standing in the context of venue, because here we have a venue is localized by statute, as well as what is required to obtain parentage pursuant to 362311.
Okay.
How long has this child resided in California?
It's our position that she resided in California majority of her life. The child was born in Nevada. And I know this is not in the record, but the purposes of Nevada was to be closer to the mother's family to birth the child. But she resides currently right now and at all times in California.
Judge Golden, that is vehemently denied by father, and it is, I mean, it's all in the record.
Okay, yeah, we got it, Ms. Rankin. We got it.
I understand. Judge Stafford, if I may, there's one thing that I would just like to say. It was a question of whether or not it was in the record that was pled about juvenile court, and it was, Your Honor. It's in trial volume 3. It's Father's amended petition, page 287 to 302.
All right, thank you. We will take this matter under advisement and attempt to render a decision as quickly as possible. We appreciate your participating. Ms. Tibner, if you will recess court until the call to docket tomorrow.
This honorable court is adjourned for the day.
Thank you.